Welcome to Protecting Your Idea with Patents, Part 2. I'm Nancy Flint, and I regularly work with my clients to protect their ideas with patents. When most people think of a patent, they are thinking of what is called a utility patent. Utility patents cover inventions like structures and methods. For a utility patent, you can file a non-provisional application or a provisional application. Provisional applications are less expensive to file, but you must file a non-provisional application within 1 year to have the application examined for a patent. The provisional application is merely a placeholder for a filing date, and it can never become a patent. There is no such thing as a provisional patent. There is only a provisional patent application. A provisional application must still describe the invention in full detail for you to claim that invention in the non-provisional application. The most important part of the patent application is the claims, because it is the claims that define your patent right. Patent infringement means that someone has made a product or process described in one of your patent claims. Because of this, your claims must be written in a way that they cover what you want to protect. Another type of patent is the design patent. This covers the ornamental design of an article. This type of patent is useful where there are no moving parts or internal structure to be protected in your invention. You should consider a design patent when other products exist that perform the same function but have different designs. The U.S. gives you a 1-year grace period after you publicly use your invention or offer it for sale to file your patent application. But you will lose your right to a foreign patent in many countries if you publicly use or sell your invention even 1 day before you file your U.S. application. The costs of preparing, filing, and prosecuting a patent application depend on the type of patent and the complexity of the invention. It also depends on whether you are a large entity, a small entity, or a micro entity. Your costs will include attorney's fees for drafting and prosecuting the application, and filing fees, issue fees, and for utility patents, maintenance fees charged by the U.S. Patent Office. While you can draft and prosecute your own application, there are risks that you should be aware of before starting. For example, you cannot make changes to your application after it is filed. If you leave details out, you may find out 2 years later when you finally hear from the U.S. Patent Office that you need those details to overcome a prior art rejection, but it's too late at that point to add those details. Next, everything you say during prosecution of your application can be used against you by the U.S. Patent Office during prosecution and also by opposing counsel during litigation, and you can limit the scope of your patent claims through your statements. If you make a mistake, your application may be abandoned. If this happens, the invention is in the public domain and it is then free for anyone to use. You need to consider whether you want a foreign patent early on. There are international treaties that allow you to first file a U.S. application, then file foreign applications within a certain amount of time. The treaties are complex and have strict deadlines, and you should consider a professional before navigating through the rules. Before filing your patent application, conduct a search to see if your idea is novel. Consider whether you want foreign protection, and file in a timely manner so no one beats you to the patent office. Contact me for a free consultation on protecting your idea with patents.